Hi, today we're going to discuss about the possibility of using the procedure of repression of abuse of rights to deny a taxpayer the benefit of an advantage offered by a tax treaty. The judgment of the French Council of State, best known as le Conseil d'État, in its 25th of October 2017 judgment, gives us some clarification regarding the boundary between tax optimization and abuse of rights. In the present case, there was a divergence of interpretation of the provisions of the Franco-Luxembourg Tax Treaty. Divergences that resulted in the non-taxation of income and capital gains from the sale of real estate located in France that was held by Luxembourgish companies and which were not represented by any permanent establishment. Since then, this gap in the law has been filled. It's also important to underline that the present tax treaty did not contain any abuse of rights repression procedure. In this context, a taxpayer, a French entrepreneur, had entered into a promise to purchase a property located in France with the option of substitution, which he had used for the benefit of a Luxembourgish company. This company, a financial holding company, was created the very same day by this very same taxpayer. He held 99.99% of this holding. The real estate was then resold to a newly created French company. This buying company was headed by his ex-wife. The capital gain could thus be tax-exempt. The French tax authorities refused to let the taxpayer to take advantage of the Franco-Luxembourg Tax Treaty, considering that this operation establishes an abuse of rights as forbidden by Article L64 of the French Tax Procedure Code, since the company did not have any substance. Article L64 of this code states that the transaction in question must firstly have an exclusively tax purpose and secondly must go against what the author of the norm intended. The Conseil of State, in its 23rd of June 2014 judgment, emphasized that this cumulative criteria are of strict application. The fact that the goal pursued by the operation is mainly tax purpose is therefore not enough to reveal the existence of an abuse of rights. In our case, it could be argued that the company had a substance insofar as it held 17% of another group's company's shares. Indeed, this participation was valued to several hundred million of euros. The court, which admitted the substance, nevertheless judged that the interpossession was justified for no reason other than fiscal. Then, the judges underlined that the taxpayer had, by putting together a scheme lacking of economic reality, merely sought to make a literal application of the tax treaty in order to circumvent the tax, and so used it in order to go against what the author of the norm intended. In other words, the judges explained that the author of the tax treaty couldn't have planned to apply these rules to situations dealing with artificial transaction. Thus, in such circumstances, the existence of a transaction lacking of economic reality is enough to admit that the second criterion is satisfied. To conclude, it's possible to apply the French abuse of right procedure in a case dealing with tax treaties, as long as such a clause is not already formulated. And then, if the French tax authorities manage to prove that there is an artificial scheme lacking of economic reality, the second criteria of Article L64 is automatically satisfied.